Okay, guys, we are going to look at the next chapter, which is concerning the collective bargaining and collective agreement. Remember, at the end of the slide or the video, chapter 5, I already mentioned that collective bargaining and collective agreement is the process after the recognition and registration of the trade union. So this is the process that the trade union could be active in their discussion with the employer or group of employers, uh, whichever it is, in order for them to gain the advantage or the benefits or the protection for their members. Yeah? But normally it goes like this: when the so-called members to get the benefit, so the non-members normally will also get. Yeah? So they tend to gain the advantage. However, as I already also mentioned earlier, if anything happens to the non-member, then the trade union has no business in coming and protecting them. So the insecurity of a non-member is higher as compared to the member itself. So we will be looking at how these two process, the next process is taking place. So if overall, if you look at the process of both, you can see here the CA process on the left and CB process on the right. So here, the invitation to bargain will start either by the employer or the union. Normally, it will be the union. So the employer, they try very much to delay, the process, because the process is taxing, tedious. Why? Because the trade union will come up with so many claims, or needs, for them to be able to comply, right? So the employer tried very much to distance themselves off or to delay the process. If you are involved as the representative of the employer later on in life, as a legal representative, then you are actually involved in the transaction. And normally, you are the first one is going to be handling the process, because you are on your employer's behalf to discuss few process. This takes time. So sometimes it goes down to 2 years negotiation. So invitation is to start to bargain between both parties, and if the invitation is accepted, then you will have the CB. Yeah, CB is the collective bargaining, where the process of bargaining, between both parties, the demand and counter demand. And then if the CB is successful, then we have the CA, collective agreement. And if the CA has been signed, then it has to be rectified by the industrial court. Yeah. So submission of the document must be passed to the industrial court to check whether it goes against the laws. Yeah. Say for example, Employment Act. Any provision that it goes against, or it is detrimental to any parties. The court has to look at all perspective. Then, if the court is satisfied, then the CA, which is collective agreement, is rectified. And then the next process will be CA becomes binding and enforceable towards both parties. Yeah, because it now has the mandatory force by the court. Now, if CA is not rectified, then CA has no legal effect. Yeah, if it's not ratified by the court doesn't see it as fit for them to recognize, then obviously it has no legal effect, and they have to go through all the process again, right? Now, looking at the CB, if there is no the collective bargaining stagnant, where there is no CA, right? By the end of the process, to and fro, to and fro, to and fro, but finally there is no meeting point. So there is no CA. If there is no CA, then it leads to trade dispute. Yeah, so this is the next level where it can go to either industrial action, which is example here picketing, strike, or lockdown. Yeah, lockdown is for the employer, picketing and strike for the employees. Next, the trade dispute can also be resolved, yeah, with a mediator. The industrial relation department can come to the rescue of the dispute, yeah, the dispute that is happening between them. Why they are to involve? Remember the industrial relationship, because the first class, because it will any dispute will impact the whole society, yeah, or the stakeholders, shareholders, employees, their families, yeah, the society in general. Say for example the trade dispute is between Pasarana and the employees of Pasarana, right? Because they are to provide many public facilities in Kuala Lumpur. So what happened is it will go if it is not settled, and then it will go to the on the left side is industrial action. Yeah, so if it's falls through, and then it will go to arbitration. Yeah, so there is no way to settle this thing. It will go to arbitration, which is the industrial court. Yeah, so industrial court will eventually award, yeah, in terms of the collective agreement, in terms of what can be done, what needs to be done, the agreement sort of like a force for parties to accept the situation. On the invitation, back to invitation to bargain. So if, say for example, the invitation is rejected or ignored by either parties, then obviously there would be no collective bargaining. And if there is no collective bargaining, since trade union is there and the dispute invitation has been made by either party, it will go to the IR department. If you are ending your career, not ending your career, if you start your career or somewhere you are there in the IR department, then you are the one that is going to settle the dispute, either from the rejection of the invitation or from the conciliation process. If you end up as the judge for the industrial court, then you should be the one that is going to rectify the collective agreement, or you are going to arbitrate the position between the employee and the trade union and the employer. Okay, that is the general overview of the process, and this process you should be able to be accustomed to this process, because the overall we'll be talking about this process that you're seeing right now. So the scope that we are going to look into is three. We are going to look at the definition and procedural requirements of collective bargaining, how it starts, yeah, and the definition and the process, as I already mentioned in the previous video. Second, we will look at the managerial prerogative, meaning their rights, yeah, in terms of whether to accept or reject, in terms of uh, what can they decide in terms of the within the process itself. So this might be involving you as the managerial team. Next is looking at the third one. We will be looking at the definition of collective agreement itself, its scope, and its effects, and towards the renewal of the collective agreement, because collective agreement have a duration or period of time, normally 2 years or 3 years. You have to sit down and start the process again. We will be looking. Okay, we are going to look at the definition and the procedure that is needed for collective bargaining to take place. if you look at the next slide, the collective bargaining is, by definition, is to improve the terms and conditions of employment of employees and promote economic welfare for the employees, or members. So towards the employers, the shareholders, they will get the money, i.e. the profit dividends paid uh, when the employees do their job very well, right? If everything goes well, there is no dispute, everyone is happy doing their job, and performance will increase. Obviously, the employer will get the benefit. Here, I would say the employer is a shareholders, not the management, meaning the management are still workers of the company itself, right? So it is a win-win situation for both parties. Next is the situation if a CB is approved, then obviously it is called an agreement. We call it as collective agreement. It is a written agreement where you put in all the terms and conditions of both parties, where they agreed upon the things that they have discussed, and it is up for a specific period. So process can be seen in Section 13 Industrial Relations Act, where it comprises of A, upon recognition of either party, spelling that, either party may invite to commence CB, as already mentioned that. Invitation must be in writing. Obviously, it must be something that is can be proved as evidence in the court. So involve letters, official letters were registered mail for evidence purposes, and then C, the employer within 14 days must reply either to accept or to reject the invitation. Right, the employer must respond because this is provided under the law. So if you are the legal officer of the employer, so you must be aware of this situation. If accepted, then 30 days for the commencement of the collective bargaining. So you can delay, provided that there is an agreement by the other party, which is the trade union. But by right, 30 days is the days that you are supposed to start commence the collective bargaining. In continuation to the process, if the collective bargaining call is rejected, then the union have the right to complain to the Director General of Industrial Relations, and the obviously by written format. And the Director General may take steps to persuade parties for CB, because tension is arising between both parties. Yeah, especially the trade union wants things to go fast, the employer wants to slow it down. So if the process fails, then it is considered as trade dispute, which is the status where the trade union can take action towards the employer, or the employer in certain situation can also take action against the trade union. Under Section 54 Industrial Relations Act, the union must make their case by issuing a statement of case, just like in the court. You have to come up with a statement of claim, you know. And on top of that, the statement of reply by the employer, just like a normal legal case, right? Where the statement is being issued and then CC for the employer, uh, then the employer is to reply back to the Director General office, and then CC back to the trade union. This also can be in a joint statement, which is quite rare for it to happen, because the tension is arising where both parties are not seeing eye to eye towards each other. Uh, yeah, okay. The definition in terms of when it comes to procedures of promotion of workmen, it is called the management rights. Yeah, whereby in terms of the promotion of workmen, This is depending on the management right itself. This can be seen from the section 13 subsection 3. What does it mean, managerial rights? They are they have the right to promote from lower to higher of a staff of their choice. So there is no restriction in the collective bargaining is not to promote workers in the trade union. So in my position last time, I was offered to be an officer to the bank. My previous post is as a clerk. Yeah. So in that situation, there is the rights of the managerial position to either promote or to a higher position or a staff that they want. And then for them not to transfer and not to demote in any way of a staff. So transfer can be done to a staff. There is no provision that the trade union is able to put up saying that no transfers are to take place. That is against the rights of the employer to do, which is to transfer out their staff. However, when transferring out the staff, they are not to demote in any way of the staff. Meaning, if the position of the clerk is head clerk, okay, or what they call it, the supervisor, if he were to or she were to transfer to another place, another branch, yeah, that belongs to the same company, then he or she must be maintained to that the previous position, or they can increase in their position. Okay, employ to new position newly available, right? So there is no rights of the trade union to restrict whatever whoever that the employer wants to employ. So if there is any position that is available, then the employer has every rights to make it open or to be able for them to appoint new people coming in. Normally, trade union try to restrict new people coming in. Why? Because the general overhead of the employer is going to increase, and therefore the cost is going to increase. The employer, when they suffered increases of cost, they would not want to engage in uh, enhancing their what they call it, the work condition, yeah, work condition in terms of the benefits, for example, installing new aircons or new security measures, things that will enhance the benefits to the employee, the current employee. So next one is termination of work by way of redundancy. So this is the right for the employer to do when it comes to too many workers. There are redundance of work, as I already given you the example of Bank Bhumiputra taking over Chung Kiao Bank, right? So if there is redundancy, then they have every right to terminate staff. Dismissal or reinstatement, that is the rights of the employer also, because they have the right to dismiss anyone that is against the contract of employment or the rules that they have already identified. They can also reinstate anyone that they want. So there is no ability for the trade union to stop them from not doing certain act in that nature. And then assignment or allocation of duties to specific tasks. So there is no rights for the trade union to stop the employer to assign or allocate duty to specific tasks of the members, right? So that is the rightful duties or rightful status, yeah, rightful status of the employers over the employees. Okay, we have covered 6.1 and 6.2 just now. We are looking at now the 6.3, which is the collective agreement definition, and it is and the scope or effects or renewal of collective agreement. If you look at the slide concerning this definition, the Act require collective agreement to be deposited in industrial court for approval or may reject in any agreement. So as I already mentioned the diagram earlier on, so the CA must be deposited with the industrial court in order for them to agree or accept or reject. So the Act gave power for the court to interpret and to enforce any approved agreement and awards in lieu, meaning if there is no solution, then the court can come up with a solution for either party. Therefore, it becomes binding to all parties and must everyone must comply to it. When talking about collective agreement, if the trade union and employer has agreed with the so-called collective agreement, right? So it does not cover all subsidiaries, because it is between the parent company and the trade union. If the company have subsidiaries, then the subsidiaries must they themselves conduct their own collective agreement in order for them to come to agreement on their own. So it is only two parties. Yeah, it does not involve those that is the what they call it, the child of the parent company. Yeah. Looking at the CA, it can only apply to those members of the union, and obviously the successors, assignees, or transferees, meaning whoever transfer coming into the company, then they are also bound by the agreement. Assignees, anyone that is assigned to work in that company, transferring, it's not transferring, it's assigned, yeah, assigned for a period of time under the company, they also will be benefiting from the trade union. And successors, meaning anyone that is coming in new in the position that is previously there, say for example A resign and then B coming in and becoming the member of the union, or maybe normally is a union of the member. So obviously the new person will get the benefits that is attained by the successors. Not successor, attained by the previous person. Okay, CA can only apply to those serving employees. Yeah, it's only logical. Those who is actually alive or active as members, they are the one that can gain the position. However, uh, those who have resigned cannot be able to claim, because they already left the company. Right? It does not it fix, or the contract does not link to them. They have no local standard to claim all the benefit because they already moved from the company. However, retirees can claim, because if you retired, a certain date prior to the agreement, if the agreement is backdated 1 year, you have already retired 6 months ago, then obviously the retiree can gain all the benefits that is being made in the new agreement or in the collective agreement. So the provision under the case of Syarikat IAC Berhad and National Union of Commercial Workers, if CA did not mention exclusion clause, then obviously it will apply to all employees, either part-time or full-time, or whether they are members or not, yeah, within the period agreed upon. But if CA did mention by the trade union that they don't want all employees to be what they call it, to be getting the benefits, obviously they have to state so, right? and it should be an agreement between the employer and the trade union to decide as such. So if there is a non-member that is outside the scope of the bargaining or the agreement, then it is considered as too bad. Yeah. This is considered as the benefit of becoming members of the union. Sometimes it benefits the non-member. Sometimes it does not. What they call it, benefit the non-member. Sometimes the non-member will get less salary as compared to the trade union because they are not represented. But sometimes the employer compensate the position of the person for not becoming the members of trade union by giving more salary, and just to create tension, right? Uh, and they have ways and means for them to manipulate. Yeah? So, looking at the CA, if the CA does not recognize some category, then the employee of that category will not gain advantages of that CA that was signed, and will somehow they are not to be discriminated, and they shall be under the exception of Section 9, which I have already mentioned. The four groups, yeah, the managerial, executive, confidential, capacity, and security. Okay, yeah, that is the exception, but that is the general rule. So, if the union wants to collect back pay, wages, allowances, and benefit, they can if they want to. But it depends on the industrial court. If the industrial court says no, then it is normal for the industrial court to reward salary and not others. So here we are talking about the primary element of things that is uh, being disputed, which is salary. Normally, when it comes to negotiation, the main priority to discuss is the increase of wages. Now, if that is the dispute between wages, allowances, and benefits, which one comes first? The industrial court will normally give the wages. But normally it is being entertained by the employer and the trade union, meaning the employer themselves. They would honor that. Yeah. So this can be seen from the RIM, Fumes, Berhad, and Metal Industry Employees Union. Looking at the content of the collective agreement, there are a few things that needs to be identified. Obviously, looking at any agreement, there would be name of parties to the agreement, the period of agreement, for how many years, and procedures of modifying or termination if both parties agree to modify and terminate, and then the procedures of problems or interpretation arising from it. Because initially you can create the agreement and you put it in writing, that was agreed upon by both parties, but later on the dispute can come up to the meaning of certain clause. So how to solve problem arising within the agreement, how to do the solution. Yeah? So that is also stated. So it comprises of several sections in order for things to go smoothly, yeah, in the agreement. For the collective agreement to be recognized, the CA must be in writing, it must be signed by both parties, yeah, and must be deposited to the registrar within 1 month of their signing. Here the court may amend it depending on the content of the agreement, whether it suits the law or bias and things like that. Element of injustice, they are non-law people, or if they involve law people, but sometimes they overlook on certain matters. So the court can come in and rectify and ask parties to amend, failing which the court will amend. Yeah, so it depends on the parties to amend upon the courts giving an advice, or they can themselves they can amend themselves, or if they don't, then the court will amend for them. The court have every rights to refuse cognizance of the CA. So parties cannot force the court to accept the CA. So bottom line, by the end of the day, it's up to the court to agree. It's pretty obvious that the court, in order for them to decide in the dispute in terms of the interpretation of CA, they must apply equity, good conscience, and merit of the case without regards to technicalities and legal form, because they are to look at the substance rather than the technical. Yeah. Next, we look at the section 56 IRA with regards to enforcement. Any complaint must be made in writing. Obviously, everything must be in writing in order for you to have evidence. And this written complaint must be to the court. And the court may direct parties to make proper application, meaning the courts will ask them for a meeting and for them to come to the court, and for the court to direct parties to comply with its proposal. So any parties who fails to follow the order shall be guilty of an offence uh, less than 2,000, or and jail not less than 1 year, not less than 2,000 and not less than 1 year, plus 500 per day as long as the non-compliance occur, provided that the court has asked the parties to do the amendment, and if they were to fail, then they are subjected to penalty. So we have the industrial court that they have no jurisdiction to render interpretation when the case was not for interpretation but for non-compliance. So they have to be very specific. They cannot cross their jurisdiction. Yeah? So even though they are empowered to make decision, but if the issue is about non-compliance, then if they come across something that is subject to interpretation, they are not to be a busybody. So they are to leave it for the interpretation of the parties to be made. If the parties disagree about the interpretation and they ask for the court to interfere and give the court's interpretation, then only then the court can play their role. So section 14 concerning the effective date of collective agreement, it will not be more than 3 years and shall become effective immediately following the date which the previous agreement expired. So if the agreement previously expired in 2018, okay, 18, and then the new agreement is formed in 2020. So it will be backdated to 2019, 19, 20, 21. So next year, both parties have to sit down and start discussing all over again. However, the court have every right to limit the backdated not more than 6 months. This is based on the provision provided under section 30 subsection 7 from the date which the ministers refers the dispute to the court. Yeah. In cases whereby cases that goes to the court, and the court have the right to limit the backdated. Otherwise, it will impact a significant amount of money. So, if you are the legal advisor for the trade union, you must be careful in terms of this situation. So you don't let what do you call it, the agreement or to be signed, you know, far from the date that it is supposed to be signed. Yeah. So this is a game of chess. You should be able to look at the party how they are playing and try your best to conclude. So, but at the same time, you also have to remember that you are to concern about the benefits of the employees. If you are for the employer, then you might also take it up that the extension can be limited by the court by 6 months. But if both parties agree, then it is not the business of the court. Yeah, only when there is a dispute for them, i.e., the court to decide. Okay, with that, we end the chapter 6. Yeah, about the process of bargaining and process of agreement. Okay, so see you in the next chapter, which is chapter 7, is when things go down south, meaning they they don't see eye to eye, things do not materialize as what they wanted. The collective bargaining did not happen, or collective bargaining happened. CA does not happen, or CA took place, but the employer or the employee and the trade union did not perform their duties as what they have agreed upon. So that is what we call a trade dispute. We will be looking into it in the next